former President Jacob Zuma may know by Tuesday whether or not he'll have to complete his 15-month jail term for being in contempt of court. Zuma was sentenced, you'll remember, earlier this year after refusing to comply with an order from the Constitutional Court that he appear at the state capture inquiry. He was jailed, but then subsequently released on medical parole. The latter, that decision was challenged, leading to the High Court in Pretoria declaring that the move itself was unlawful before setting it aside. The appeal to overturn the judgment will be heard, as I mentioned, this coming week. So we want to know, what are the prospects of Zuma's eventual success? Let's unpack this now with legal researcher Nkanyiso Ngqulunga, who joins us now via our video link. And it's great to have you on the program, sir. Thanks always for making time. We know, procedurally speaking, what would have to happen is that the former president's lawyers would have to first apply for leave to appeal before the appeal itself is actually heard. At which stage are we come Tuesday?
So following the judgment of the Gauteng High Court, which found that the Commissioner of Correctional Service had not complied with the procedure that's provided in the legislation to grant a medical parole to Mr. Zuma. So after that sketching judgment by Judge Matojana, so they have actually launched a leave to appeal, of which a leave to appeal is going to be a precursor for them to be able to appeal the main judgment, of which I've just highlighted that it has found that the decision was unlawful and has been effectively set aside. So one would look at the prospects of success of before the leave to appeal is decided. So the judges will have to be looking at the prospects of the success in the appeal itself, so that they are able to grant a leave to appeal. But if the court is of the view that there is no prospects of success, then the leave to appeal won't be granted, and I believe that they will have then to take it further to the other upper courts, be it the Supreme Court of Appeal or be it the Constitutional Court. But I believe that for the case to be determined on its merits, to understand whether or not there are prospects of success, the court will have to satisfy itself based on facts and based on what was ruled in the judgment before they could even entertain the main appeal application.
Right. So really on Tuesday, we're going to hear an application for an appeal to take place before the appeal itself. And when that appeal takes place, if it does, I mean, what do you reckon are the sticking issues? Already we've heard a lot of commentators mentioning that this issue around being terminally ill as a requirement for medical parole is certainly set to take center stage.
I mean, this is really a very difficult case for them if they took it to appeal, because in my view, I think a wrong premise was used to grant the medical parole, and I don't think it's easy to remedy that situation. And firstly, we would know that there was like an entire new regime of the legal framework for the medical parole that started in 2012. And I think that the High Court does highlight that extensively in its judgment, that who is supposed to take a decision that someone must be out on medical parole. And then secondly, and I think that how the process is unfolded, it was a rushed process. There was just a lack of adequate considerations that are provided for in the state for them to arrive, at an appropriate decision. So, and thirdly, according to what we've read, the daughter's report, not only the daughter's reports, but the recommendations from the parole board, neither of the two actually suggest that President Zuma is incapacitated to continue with his 15 months sentence. So it makes the appeal to be very difficult, and unless, of course, they are bringing compelling legal reasons that would perhaps prove that this was in the public interest, and I don't think that how that argument would help them succeed with the appeal itself.
Yeah.
So it's going to be a very difficult case for President Zuma and his legal team.
The complexities don't end there, of course. From the ruling by Judge Matojana in the High Court in Pretoria, what was also mentioned there is that there needs to be a commitment to sending that strong message that no one is exempt from the tenets of the law. And that was very reminiscent of that judge from the High Court penned by Sisi Kampepe, where the thrust of why Zuma was sent to jail to begin with was to send that clear message that anybody who disobeys what the courts have to say at the very least will have the full might of the law meted against them. It's going to be a tough one to try fight against at least that aspect of the High Court judgment that we saw this week?
Yes, definitely. There's seemingly a very vicious ways of dealing with the law. When from the President Zuma is a litigant, I wouldn't want to say an unscrupulous litigant, but he's someone who's been in and out of courts to defend and using all the legal maneuvers. So his case is a very difficult case because he's a former head of state, and oftentimes they've used that and that he's excusable for legal accountability for whatever that he's accused of. And I think we've seen that these tendencies within the current governing party trying to do all these favors in exercising of all this executive authority in favor of their comrades, which effectively does affect our constitutional order, and it suggests that some people are actually more better when it comes to the law. They are treated differently than others, of which I think that's not what the Constitution envisaged when it says everyone is equal before the law. It doesn't matter if you're a former head of state or we are just an ordinary citizen. So all these favors does in fact compromise or impugn on our constitutional democracy, and I think that's why the courts have been so clear and concise in delivering this message that the politicians will have to respect the law, and I think it's a message that wants to bring judicial finality and wants to bring the order in our country, because if we were to just sit back and allow such things to happen, then it would just open a very wrong precedent in our country that some people will actually have these favors at their disposal once they're in trouble or once they are found against the law.
You allude to judicial finality. The reality, of course, is that this particular appeals process itself may take some time. And when you consider the position that Jacob Zuma is currently in, an elderly man who isn't doing well health-wise, during this period, there may very well be a stage where a legitimate reason does come up for him not to go back to jail. What happens in that context?
Well, I think that this issue will be dealt with a matter of agency, because we understand that President Zuma is sentencing ends in October 2022. So I believe that the matter will have to be concluded within a very short period, and as that's why I think that the application for the appeal will be held Tuesday. I may not have time frames because of the courts have their own way of administering their cases. But Mr. Jacob Zuma was, in fact, supposed to be due for the parole, I think in October, before the rush process to remedy the Constitutional Court sentencing of Jacob Zuma. So he is someone who, in fact, was going to be due for like the normal parole, like any other inmate, not the medical parole, but just like once you have served at least a quarter of your sentencing. So that's one consideration that I think would have actually been able to assist Jacob Zuma when he was in prison. I think it would have been a very adequate process and a straightforward process for him that was going to be lawful, in fact. I don't think any reason, I don't want to preempt whether or not the president's health is at what stage, and I don't want to suggest anything because I'm not aware or not privy to any of the medical documentation that's out there. But I think that in this case, there's nothing that I think could prevent him being taken back into prison, in fact, to continue to serve his 15-month sentencing, unless the normal parole of which they themselves raised in an application, in a review application, they raised the issue of mutinous when that if this application were to succeed, then it therefore becomes moot because the president was going to be due for. But the judge was of the view that no, now that this decision has been taken, it would be appropriate for the court to rule on it because it is the public interest, and administrative authority has been exercised in a manner which was unlawful and invalid. So I believe that what they still have at their disposal is basically to apply for the normal parole, of which I believe Jacob Zuma is now due for it. And secondly, one would expect that some people have raised the issue of presidential pardon. Presidential pardon are very complex because it's an exercise of an executive authority. So it can never be done for an individual. And I think that we all know that President Mandela in the early 90s was faced with the same dilemma and was even taken to courts. So I think that for any presidential pardon to be done, once every litigation has been concluded and done, then an individual can apply to the president for a presidential pardon. And a presidential pardon cannot be applied to individuals. It will have to apply to a certain bunch of people, and the president will have to establish a certain criteria for all those people who will be due for a presidential pardon. So it's really a very complicated situation for our former president.
Nkanyiso Ngqulunga is a legal researcher. It's great to chat to you, sir. Once again, thanks very much indeed for your time.